Welcome, everybody, and welcome to this latest Fox Williams Travel Team webinar. And as has become the norm for these end of year webinars, we tend to look forward into the next year and we pick some topics which we think are worth everyone looking at going into next year, and what are likely to be, some of the legal issues which arise and which are going to need to be addressed. So there are four topics on the agenda today. I'm going to kick off and talk a little bit about secret commissions and things which have been happening in this area. Lucy England is then going to talk about sort of commercial contracts, common pitfalls and key themes, maybe picking out some of the things that Lucy has seen from her work in this space. We're then going to have David Williams talk about employment developments. I mean, obviously, this is a very hot topic at the moment with the Labour government introducing a raft of employment reforms, which are going to keep everyone busy next year. And then we're going to finish off with Farina talking about some international regulatory issues that have crossed our desk and which are worth talking about. So we are going to aim to go for about 50 minutes, leaving about sort of 10 minutes at the end for questions. We are going to try to finish on the hour so that everybody can get back to work. Don't worry, all of your cameras and your microphones are off, so nobody can see you or hear you. But if you want to ask a question, you can do so in the Q&A button, which should be on the screen. So if you want to put questions in there as we're going along, and we'll try and pick them up at the end. If there are any ones which we don't manage to get round to, very happy to follow up afterwards on those. I would just ask that when you do put the question in, sometimes they can be quite difficult to understand if they're typed very quickly. So if you'll have plenty of time to type it because we'll only deal with them at the end. So do take your time to write those questions. So on to the next slide, please, Bailey, and we'll kick off. And next one again, please. So secret commissions. Why are we talking about this now? Well, the reason being that there have been some high-profile cases recently on this issue of secret commissions. They are in other industries. However, the principles that the court has applied in those other industries are equally as applicable to the travel industry. And given that we have many different forms of agency relationships and intermediaries in the travel industry, I thought it was worth picking up on this because there are definitely lessons to be learned from these other industries which are likely to carry across into travel. So, I mean, the two cases I'm particularly thinking about. At the top of the slide here are news articles. I'm sure if you read the news, you will have come across these. So this is the car finance case that was recently heard in the Court of Appeal, where a basic situation is consumer goes into a dealer to buy a car. The dealer agrees to source some finance for them. The dealer presents them with a finance offer, which has been presented on the basis that it's competitive, maybe from a lender or a panel of lenders. And unbeknown to the consumer, the dealer, who was acting as a broker for the consumer, was receiving a kickback from the lender. So in those cases, the Court of Appeal decided that those commissions were secret and were unlawful. And as a result, for reasons I'll come on to, the lenders in those situations have been ordered to pay the consumer the amount of the commission. And as a result of this, the banks are very nervous and about the potential significance of their liabilities here. And the latest estimate I saw in a news article was that the banks were estimated to have a potential liability of 30 billion for all of these commissions. So pretty significant. And like I said, of relevance to the travel industry for reasons I'll come on to. The two news articles along the bottom are ones in relation to energy brokers. So, similar situation, except this time the customer wasn't a consumer, the customer was a corporate. So, somebody like Fox Williams would appoint a broker to find them the best energy deal. Um, the broker would bring back an energy deal, and unbeknown to the company, the broker was getting a secret commission or a kickback from the energy company. And in those cases, there's actually a class action going on at the moment where I think the claimant firm, law firm, is suggesting that the total value of those claims could be somewhere in the region of 2 billion. So quite significant liabilities there. So next slide, please, Bailey. So looking at, coming on to the travel industry, I've just got two diagrams here on this slide and on the next, which kind of illustrates how the issue might arise in the travel sector. And on this slide, I have a model, very simple model of a typical travel agency appointment where the principal in this situation is the airline or the hotelier or some other travel supplier, appoints the agents, the travel agents, to sell their travel services to customers, which may either be consumers or corporates. And the travel agent will be paid by the principal. Yeah, maybe they're getting a fixed or variable commission from the hotelier, for instance. And the secret commission issue would arise and becomes problematic if the customer is actually paying the travel agent as well. And depending on the precise circumstances, that may either be secret commission or partially disclosed commission. Now, the legal consequences of both are different, and I'll explain them on the following slides. But just to explain what I mean by these terms, secret commission is a situation where the customer is paying the travel agent, and the principal is completely unaware of that, so has no knowledge of the payment. And partially disclosed commission is a situation where the principal knows that the agent's getting something from the customer, but they don't know what. So, typically this would be some sort of term in a contract which says, very vaguely towards the very back, by the way, we may get paid by the customer. So, arguably there has been some form of disclosure of the payments by the customer, but the principal doesn't know exactly what is being paid. So that's the first kind of situation. Next slide, please, Bailey. Now, the other sort of common situation in the travel industry, I mean, the principles here are exactly the same as on the last slide, but here the principal is the consumer or the corporate, so the customer. So this is the travel agent acting as an agent for the customer, basically. And exactly the same sort of issues arise. If the travel agent is getting a payment from the travel service provider in this situation, which the customer doesn't know about, then that would be a secret commission. If the customer knows that the agent is getting something but doesn't know what exactly, then that's partially disclosed commission. So, this could be a situation where the travel agent is kind of maybe adding a markup onto a price of one of the travel services without telling the customer, and is also being paid by the customer as well. So in those situations, depending on exactly what's happening, that could be either secret commission or partially disclosed commission. So next slide, please, Bailey. So just going on to the consequences of these different commissions. So secret commission first. Now, basically, the way that the law works is that there's a prohibition, there's a total prohibition on secret commissions in one of two situations. One of which is where the travel agent has assumed some sort of advisory role in the relationship with the principal. And as a result of that, they've taken on an obligation to be impartial, to give disinterested advice, information, or recommendations. Um, so in those situations, because the travel agent has this kind of obligation to be impartial, secret commissions are not allowed. And in the travel sector, I suppose the most obvious example of this would be perhaps a situation where a travel agent is um, advising their customer, could be a corporate or could be a consumer, on the best itinerary, the best flights, maybe the cheapest flights, whatever it is for their particular journey. And if they're sort of taking on that advisory role, then taking a secret commission customer doesn't know about, assuming that the customer is the principal, is not allowed. Um, a bit more difficult to see how this would apply in an OTA type situation. I could possibly see it coming into play where the OTA has a search engine which is um, presenting, information to them, recommendations to the customer in response to criteria that they feed in. I suppose in those situations, you could see how a court might conclude that the OTA has assumed some sort of obligation to present that information impartially. So if they're then receiving, commission, acting as an agent for the customer that the customer doesn't know about, then that would be a secret commission and prohibited. Um, the the other situation where secret commissions are prohibited are where, in addition, well, separately to this impartiality kind of advisory concept, situations where the travel agent owes fiduciary duties to the principal. Now, this term, fiduciary duties, is obviously a very legalistic term. Basically describes a situation where somebody has agreed to act for somebody else in circumstances which give rise to kind of an obligation of trust and confidence. So if you think of a classic example would be a director of a company has obligations of trust and confidence, to act in good faith without a conflict of interest, that kind of thing. But classically, the courts have typically found that these duties arise in an agency situation. And the reason for that is that the principal is actually in a bit of a vulnerable position because the agent is in a position to kind of bind the principal to contracts. So because of that sort of potential, vulnerability that the principal has about the actions of the agent, the courts, usually finds that the agent does owe fiduciary duties to the principal in those circumstances, and therefore, as a result of that, they have obligations to act in good faith, avoid a situation where the agent's commercial interests conflict with the fiduciary duties that they have to the principal, that sort of thing. So that's another situation where secret commission will be prohibited. Um, Now, the consequences of um, taking secret commissions, a couple of different consequences. Surprisingly, um, the agent in this situation has a liability, but also the person making the payment. And those liabilities will either be to pay the principal the amount of the commission, or alternatively to pay the principal or to compensate the principal for any damages that they've suffered because of these breaches of duties by the agent. So I don't know, maybe if the principal has suffered some losses because the agent has entered them into a duff contract, then those losses would be recoverable. So that basically means having to pay money. The other perhaps slightly more scary situation is that the principal in these circumstances also has the option to rescind the contract. Um, and what that basically means is that the principal can insist that the contract is unwound, so that everyone's kind of put back in the position where they were before this secret commission was paid, which would basically mean, I suppose, the principal getting back the money that they paid at the very beginning, so that they're kind of in the position they were before before the agent entered them into this contract. So that secret commission, I'll just deal very quickly with partially disclosed commission, Max Bailey. So partially disclosed commission is only prohibited where the travel agent owes a fiduciary duty. So this disinterested duty that I talked about earlier isn't in play here. But the interesting thing here is that it is possible to avoid any sort of liability if the principal gives their informed consent to the payment. And what's required to obtain that informed consent will depend on the circumstances and the particular relationship between the principal and the agent. And I would suggest that there is likely to be a difference where your principal is a corporate, where perhaps it is acceptable to disclose the fact that you're receiving commission in a negotiated contract, albeit perhaps not the exact amount, whereas your obligations are likely to be much higher when you're dealing with when your principal is a customer, where putting something in the terms and conditions probably isn't going to be enough, and there probably needs to be something called out during the customer booking journey, I would think, to get informed consent. So again, consequences are similar to before. I'm not going to dwell on these. The only differences here are that not quite as easy for the principal to unwind the contract, and the paying party doesn't automatically have a liability to damages to the principal. They have to have acted in some way which is kind of dishonest, basically, in order for the paying party to be responsible. So next slide, please, Bailey. And this is the last slide. So things for the travel industry to think about. Well, in no particular order, perhaps. Firstly, figuring out who your principal is, and what your position is in a particular transaction, because often it's not clear. Obviously, often the contracts aren't clear, and often, as the car finance company has found out, it's not clear, and often it's open to interpretation, and that interpretation, if it's put before the courts, can go against you. So I think it's important to identify who your principal is, and then understand what your duties are to them. I mean, do you have any sort of disinterested duty, obligation to give disinterested advice? Do you owe fiduciary duties to them? And if you do, then obviously potentially that incurs a risk, because if you're then making profits or receiving benefits that your principal doesn't know about, then that potentially contravenes the prohibition against secret commission. Obviously, you can protect against that by making disclosures to negate secrecy, bring it into the partially disclosed commission area, and then to avoid liability in that area, then obviously the disclosure needs to be sufficient so that the principal is able to give you their informed consent so that you can receive this payment. So that's a whistle stop tour of secret commission. I've slightly overrun, but on that point, if there are any questions, we can pick them up at the end, but I will hand over to Lucy.
Reese, morning everybody. So topic 2 is something totally different. We thought we'd do a quick look at some of the sort of commercial contract law points that we commonly come across and have during the course of this year and continue to see into next year. Next slide, please, Bailey. And in thinking about what to talk about, there was quite a long list, so I've just focused in on 2 quite particular areas. And the first one you'll be delighted to know, because everybody loves a bit of case law, is just looking at a very quick case on imprecise drafting and the consequences that can have. Anybody that looks at contracts knows the importance of making everything as clear as possible. Even when you think it's clear, somebody else might not. So we'll just look at a case on that. And then the second one is something that we keep seeing, which is either businesses asking for or businesses being asked for an indemnity for any breach of contract by them, sort of what that means and how you could avoid it if that's what you want to do. So next slide, please, Bailey. So first up, this case was heard in the Court of Appeal during the summer this year. Cantor Fitzgerald and Yes Bank. Yes Bank was an Indian commercial bank. Cantor Fitzgerald was an investment bank, but in this context, it was a financial advisor. Yes Bank, the short facts are Yes Bank got into financial trouble, needed some investment, and Cantor was one of several institutions engaged to help them on the terms of an engagement letter. Cantor was engaged to act in connection what was defined as a financing, which I'll come on to. And if Cantor helped with that financing, they'd be paid $500,000 as a retainer, plus 2% of any funds raised from that financing from a list of particular investors that were in the engagement terms. Next slide, please. So it was, quite a huge amount of money because they were talking 400 million. So 2% of 400 million is obviously quite a chunk. The engagement letter defined financing as the private placement, offering, or other sale of equity instruments in any form. So that's just a part of the engagement letter. The end of the investment story, long facts of the case, but was that Yes Bank actually took investment in the end by way of a public offering. And Cantor said, well, including by 3 of the investors that were listed in the engagement terms between Cantor and Yes Bank. So Cantor was saying, well, you've got investment from the people on our list, therefore we should be paid our 2% of the funds. And it came to about $7.5 million. And that's what they were claiming. But Yes Bank was saying, no, it's not covered because what you were being asked to do was help us with private funding, not public funding. And the question that got to the Court of Appeal was whether the adjective private at the start of this list qualified every item in the list or just the word placement at the beginning. And you can read it several times and make your own judgment. But the court said that the word private actually applied to every item in that list, so private placement, private offering, and any other private sale of equity instruments. And the impact of that was that Cantor did not get their uplift because it was done through way of a public offering. And I mentioned this case, one, because it's such a simple concept, which has had quite obviously a big impact on Cantor Fitzgerald, but it's quite an easy thing to fix when you're drafting contracts, to look at something like that and try and address it if you need to. And I think it's just also a good reminder that the English courts do look at the ordinary meaning of words on the page. They don't read into things if it's clear, and to them this was clear. It just wasn't what the parties intended it to be when they wrote it. So that, I thought, was just a nice simple case just to explain why obviously clear drafting is always very important. Next slide, please, Bailey. The next thing that I've seen a lot this year, and the reason I raise it, because it's seen a lot more almost in travel contracts than other contracts that we look at, and whether it be between travel service supplier and travel agent. Sorry, I should say this is all in the B2B context, not in the B2C context, or vendors, software vendors, tech vendors. We see a lot of requests for our clients giving indemnities for any breach of their contract, and it will look something like that on the slide. And I suppose the point I want to make is, even though they do appear in many contracts, there isn't any requirement, certainly under English law or as far as I know, I'll say any law, but certainly under English law, to accept it, to include it. It is like with all indemnities in an English law contract down to negotiation. But the impact of including it is big, because it puts the whole contract on a totally different footing if there is a breach, and you're not looking at a damages claim, but you're looking at recovery on an indemnity basis, which in under English law is very different. And next slide, please, Bailey. And so I thought it was just worth mentioning or reminding ourselves, none of this is new law, but just reminding ourselves, for everybody that deals with contracts, and that's probably everybody on this webinar, what the difference is and what that impact could be. And then thinking about these things when you're doing your end of year contracts, trying to get things over the line before Christmas and the new year, maybe some ways you can try and soften the impact if you are being asked for these types of indemnities. So just very quickly, with a breach of contract claim, you obviously must prove breach, but with an indemnity claim, you don't have to prove it. Once the indemnified event has occurred, the promise to pay becomes an obligation to pay, and that's key. What is the trigger? So any breach is very broad, and any breach is therefore going to lead to an indemnity claim. Under a breach of contract claim, you've got to show a causal link between the breach and the damage, but that's not the case with an indemnity. If the trigger has happened, you're then into a debt action recovery claim where there's no burden of proof, and it's a much easier route to claim. There's a duty to mitigate generally at common law for a breach of contract, but there isn't such a thing with indemnities. Indemnified party has no general duty to mitigate its loss. So if one way to soften, if you like, the indemnity that you might be being asked to give is to ask for the party being indemnified to at least have an obligation to mitigate its loss, to lessen what could happen if the indemnity happened. The loss must not be too remote with a breach of contract claim. It can't be so far removed that it shouldn't be recoverable. And there's a link there to sort of direct and indirect damages and that concept. But the idea of remoteness, again, doesn't apply to indemnity claims. So the question that you always have in negotiation of whether indirect losses should be excluded from indemnity claims is almost more important in that context. And then finally, the big question is, are the losses under a breach of contract claim versus an indemnity claim caught within any liability cap that you have in the contract? Now, there used to be, I think, a school of thought that breach of contract claims were within the cap, but indemnity claims were perhaps outside the cap. I'm not sure that's actually true. I think if there is silence on it and it's just everything is caught by the cap, that would include indemnities. But as I thought, just be very clear about whether your indemnities are inside the cap or not when you're drafting it. Next slide, please. So just a few things to take away from those 2 points. Like I say, they've been very precise, but it's quite a big topic. And I would just say, if there are particular topics that you'd like us to cover on the sort of contract law side of things, let us know in the feedback form that you'll be sent, because we'd be very happy to do more of this. Check the boilerplate is the first thing. It's often gets obviously scanned over, but the engagement letter, I think the term that caused the problem in the Cantor Fitzgerald case was just boilerplate terms, hadn't actually been looked at, and that was the cause of the problem. So I think that's the takeaway from that case. And then on the indemnity side, I think the list concept in Cantor Fitzgerald, just think about how you could unpack that a little bit to make it even clearer, perhaps dividing it up a bit more, looking at the interpretation provisions, just adding language to make it more clear. But then on the indemnities, if you are being asked to give this any breach type indemnity, just think very carefully about who you're actually indemnifying, whether it's broader than it needs to be, whether you can water down or be more precise on what the trigger for the indemnity is, as I mentioned earlier, what can be recovered? Is it direct, indirect, more than that? what should there be any conditions to recovery, such as notification? The indemnity doesn't apply if you're not told about it, for example. And as I mentioned, adding a duty to mitigate with indemnities, which often isn't included, but is quite an easy thing to ask for and is often accepted. So something to think about there. So that is all on contracts. I'm sure that's plenty for a grey Tuesday morning, and I will hand over to David.
Thank you very much, Lucy. Hello, everybody. So I'm going to do a quick update from an employment law and HR perspective, focusing on two things. Firstly, the new duty to prevent sexual harassment, and secondly, the raft of changes which have been proposed in line by the government in line with the government's new employment bill. So let's start off with the new proactive duty on employers to take reasonable steps to prevent sexual harassment. And this came into effect on the 26th of October. So the first question is, what are reasonable steps? Well, hopefully the government has provided guidance, which includes 8 basic steps, and I should say includes, these are not exclusive, 8 basic steps which are set out on the slide. One of the most important of these is the risk assessment, which needs to be undertaken first and needs to take into account aspects such as any previous claims or grievances and learning from those, any situations where there may be an imbalance of power within the organisation, and any high-risk considerations such as certain social occasions. The point is that the assessment needs to be tailored to your business and come up with an action plan which is likely to involve things such as updating your policies and processes and tailoring them to your business. Training, albeit note that basic generic online training is unlikely to be sufficient. Effective complaint handling, and finally a process to regularly review and monitor what is happening, perhaps every 12 months. Notably, the duty covers both workers such as consultants and employees, and businesses are also obliged to prevent harassment of such individuals by third parties such as customers. In terms of non-compliance, the duty is likely to have 4 implications. Firstly, compensation payable in relation to relevant claims may be increased by up to 25%. Secondly, it may make it easier for individuals to bring individual sexual harassment claims because they will point to a lack of rigour on the point of the employer. And thirdly, it can lead to instigating investigations into your businesses and issuing warning notices. But the most important implication is it can cause enormous reputational damage. If that's not enough, the employment bill, which I'm going to come on to in a few moments, proposes further changes. Namely, reasonable steps will be replaced by all reasonable steps, so the burden is going to get much harsher for employers. Disclosures about harassment will automatically be regarded as protected disclosures for whistleblowing purposes. And finally, employers with more than 250 employees will need to produce equality action plans, which will need to address things such as gender pay gaps and supporting employees through the menopause. So let's move on to the next slide. Now the employment bill, which you probably heard about, sets out a raft of changes which the government plans to introduce, with these coming into effect from April 2026, but they are currently consulting in relation to them. I'm going to start with a grouping of changes which will apply from day one. In terms of unfair dismissal, the proposal here is to remove the requirement that staff need 2 years' service in order to bring a claim. In order to counterbalance some of the impact of the change, the government is proposing a 9-month or so probationary period, during which staff can be dismissed provided some sort of basic process is followed. The exception to the new probationary regime will be redundancy dismissals, where staff will have unfettered unfair dismissal protection from day one. Another notable change to unfair dismissal claims, and indeed all potential employment claims, is that employees will have 6 months from the date of termination of employment to bring a claim, instead of 3 months, which is currently the position. The implications of these changes is that they are likely to significantly enhance the potential for unfair dismissal claims. The next major change relates to flexible working. At present, employers need to apply their minds to requests properly, but may turn them down having regard to one of the relatively wide-ranging statutory grounds. Moving forward, employers will only be able to refuse an application if it is reasonable to do so, essentially replacing a subjective test with an objective one. In notifying the employee that their request has been refused, employers will need to state the ground relied upon and explain why they consider it to refuse the application. Now, this is a contentious change at the moment, with many employers trying to get staff back into the office and make other changes to their employment terms. And in practice, it's going to make it much harder to refuse flexible working requests and lead to a flurry of employment tribunal claims. As to family-related leave and SSP, the bill proposes to make 4 key changes. Firstly, the bill will remove the qualifying service requirement for paternity leave, currently 26 weeks, and unpaid parental leave, currently 1 year, and these will become day one rights. The bill will strengthen protections for pregnant women and new mothers, making it unlawful to dismiss a pregnant worker within 6 months of their return to work, except in specific circumstances. The third key change is that the current provisions on parental bereavement leave will be extended beyond parents and create a general right to bereavement leave. Leave will remain at 2 weeks following the death of a child and 1 week following any other bereavement. And finally, in this context, the bill removes the waiting period for SSP and the earnings limit, meaning that all workers will be entitled to SSP from the first day of illness. Now, given that many employers are facing an epidemic of staff on sick leave, this is quite a contentious change. As to 0-hour contracts, these are going to be abolished, and instead employers will be required to offer guaranteed hours to workers calculated by reference to an incredibly complicated system. If you have trouble sleeping, then please go ahead and read those. The legislation will also give workers the right to reasonable notice if they are required to work a shift or if a shift is cancelled or changed. So on to the next slide. As to trade union reforms, now pay attention. If you don't have a trade union now, you may soon have one, because the bill effectively does 5 things. Firstly, it obliges employers to promote trade union membership, likely to be part of the Section 1 particulars that you need to give employees at the start of employment, and this will need to be repeated every 12 months or so. It will also make it easier for unions to gain recognition and arrange industrial action on the back of that recognition. And when industrial action is called, this can be called at shorter notice being given to the employer, and the industrial action can potentially last for longer, thus increasing the bargaining power of the unions. The bill also enhances the rights once a union is recognised. There'll be an obligation on an employer to enter into access agreements, which will give unions right to meet, represent, organise and recruit workers and to facilitate collective bargaining within your workplace. Next up, the employment bill expands the protection of staff taking part in industrial action and makes it easier for union funds to be diverted for political purposes. I should add that the bill will abolish any requirement on employers to maintain minimum standards of performance, such as in relation to train travel, although I should mention that these changes introduced by the Conservative government have never been relied upon. Moving forward to changing terms of employment. Now, this is really important as businesses grapple with AI and changes to business models. The government plans to prevent employers from introducing new terms by terminating staff and offering them new terms, which is essentially what P&O did when it replaced its staff with cheaper workers. The new rules apply unless the business is effectively on the verge of collapse. This means that the options available to employers to change terms are, well, they can simply impose the terms, but this creates a risk of constructive dismissal. They could rely on variation provisions, but these are construed narrowly against the interest of the employer. They can agree the change, although staff are likely to want some sort of consideration or payment for this. Or finally, they could do something more drastic, such as a redundancy programme, provided, of course, that's not prevented by the anti-avoidance legislation in the employment bill. In summary, the options available to change employment terms are going to be more limited going forward. As to collective redundancies, currently an employer must consult collectively with appropriate workforce representatives in cases where 20 or more redundancies are proposed within a period of 90 days at one establishment. Now, the bill proposes to remove the reference to one establishment. The amendment was prompted by the closure of Woolworths in 2011, following which it was held that each branch was an establishment in its own right. So the duty to consult only applied where 20 or more employees were dismissed from a particular branch. The change will mean that the obligation to consult collectively in relation to redundancies will be triggered more often, and it will lead to unwary employers being caught out. Against this background, I should add that the government is also proposing to increase the penalty for non-compliance from 90 days pay to potentially an unlimited amount, which could be potentially painful. So what are the takeaways from this, and what are the action points? Well, firstly, there's the immediate action point. Make sure you are complying with the anti-sexual harassment rules and actually do a good job of this. Many people have done something, but they haven't done it with rigor and with sufficient detail and due diligence. Moving on, things that you should be looking at next year before the employment bill is introduced. Firstly, make sure your recruitment processes are robust in the light of changes to the unfair dismissal regime. Secondly, update and review your employment contracts and provide as much in the way of rights to vary them in the future as you can possibly get into those contractual arrangements. Next, get any reorganisations done in the light of the changes to the collective redundancy regime. Next up, you should review your approach to flexible working requests to see whether you can start to define what is reasonable in any particular circumstance. And finally, if you don't have a trade union body, you should consider setting up a staff body with teeth, and you need to get that done as soon as possible. And that you can use that as a way of saying that you've got something active that's working with your organisation as a way of avoiding recognition, if that's the way that you would like to go. And on that note, I'm going to hand over to Farina.
Thanks, David. So I'm going to use sort of the last 10 minutes of this session just to go through a couple of international regulatory developments that have crossed our desk. So specifically, I'm going to be talking about the new US Department of Transportation rules on flight delays and cancellations. And I'm also going to talk about a Spanish regulation that came into force this year for accommodation and car rental providers on data sharing with the Spanish authorities. So these are developments that have come across our desk this year, whether because they've been mentioned by clients or whether because they've been mentioned by our international network of local counsel. And you'll see as I go through the regulations that they do have quite a far-reaching scope, and especially with the US rules, has a much wider impact than I think was sort of initially considered. So if we start with the US Department of Transportation rules on flight delays and cancellations. So these came into effect on the 28th of October of this year. And essentially, the US DOT has created a set of universal standards for refunds which are owed to airline passengers when those passengers are travelling on flights to, from, or within the United States. So before these rules came into play, it was a slightly more ad hoc system. Airlines could, had a bit more discretion over when to give refunds. And so this was, especially I think in light of everything that happened with COVID, this was sort of the US DOT deciding that, what is required here is a set of universal standards. One of the key things to note, though, with these rules is that they not only apply to airlines, but they also apply to ticketing agents. So any airlines or ticketing agents which sell flights to, from, or within the US are caught by these rules, and that's irrespective of where the airline or the ticketing agent is based. So that's what I was referring to when I said actually the rules have a really wide scope, because it's based around the flights and flights going into, out of, or within the US. It's not necessarily based on where the customer is resident or where the airline or the ticketing agent is resident. So there has been some media attention about these rules, and one of the main things that everyone seemed to pick up on was this automatic refund right that the rules give. So airlines are under an obligation to provide an automatic refund. So that means that it's not on customers to initiate the refund process. It's actually on the airlines to make these automatic refunds where a customer is entitled to one under these rules. So these the automatic refund or the refund right comes into play in the following situation. So in the event of a flight cancellation, so it would be a flight cancellation where either the airline doesn't offer a rebooking or doesn't offer an alternative compensation, such as a voucher or air miles, or the airline does offer it and the customer doesn't accept either the rebooking or the alternative compensation. So an automatic refund would come into play there. Customers are also entitled to an automatic refund in the event of a significant change to the flight, and a significant change does include flight delays. So the flight delays have to be more than 3 hours for domestic flights or 6 hours for international flights. And in those scenarios, then the automatic refund right comes into play. There are other situations that would also be considered a significant change, such as a change of airport, or where there's been an increased number of connections in the customer's flight, or where the customer has been downgraded to a lower class of service. So all of those are considered significant changes, and the automatic refund right would apply. Other scenarios where a customer would be entitled to a refund include where a customer's baggage has been delayed. So it has to be delayed by more than 12 hours for a domestic flight or 15 to 30 hours for international flights. And that would just depend on the length of the flight. And where customers have booked extra services, so where they've booked sort of, Wi-Fi or seat selection, and they don't receive those extra services that they've paid for, customers are entitled to an automatic refund of the fee that they have paid for the extras that they didn't receive. The automatic right to a refund no longer applies, though, where the customer does accept a rebooking or where the customer does accept the significant change or the alternative compensation. So that would then extinguish the right to an automatic refund. So the refund has to be made back to the original form of payment, and the timescales for that are within 7 business days, sorry, for credit card purchases, and 20 calendar days for any other payment methods. And an airline can't substitute a cash refund with a voucher or a travel credit or another form of compensation unless the customer explicitly chooses to accept that alternative compensation. And where the alternative compensation is a travel voucher or a credit of some kind, it has to be valid for at least 5 years from the date of its issuance. And the last point on the actual process is that the full amount of the refund must be refunded, and that includes all government taxes and fees of any kind, irrespective of whether the airline is going to manage to refund those or not. And the only thing that can be deducted would be the portion of any of the flight that's already been taken. So as I mentioned at the beginning, one of the interesting things about these rules is that it does actually bring ticketing agents into the scope of these rules. So the ticket agent is responsible for the refund where it is the merchant of record, so i.e. where it has collected the payment from the customer, and that applies regardless of the location of the point of sale. But ticket agents are not subject to the automatic refund liability. Ticket agents have essentially what's an on-request liability. So where a customer informs the ticket agent that their flight has been cancelled or significantly changed, the ticket agent can then reach out to the airline to confirm that, yes, this was the case, and to confirm whether the passenger is entitled to a refund under the rules. Airlines do have a regulatory obligation to inform the ticket agent in a timely manner whether or not the consumer is entitled to a refund. But then once that is confirmed, the refund must be made by the ticket agent within the usual timescales. So that would be 7 business days for credit card purchases and 20 calendar days for any other payment methods. So that, I think, is one of the biggest issues with the new rules, is the fact that the scope is so wide, and it does bring in ticketing agents, it does bring intermediaries within the scope. And although there has been some media coverage, and I have seen some articles about it in the press, I don't think there's really been enough attention on how wide the scope is and how many companies and ticketing agents it actually pulls into the scope, and the fact that many of our clients that maybe UK based but are selling flights to the US could find themselves within the scope of these particular rules. So that covers the US DOT rules. I'm now going to move on to very quickly the Spanish regulation on data sharing. So this came into effect on the 1st of October 2024. However, it did have quite a long lead-in period. And this was, you'll see as I go through, this was actually not just to allow sort of travel companies that are impacted the chance to implement, but also to allow the Spanish Interior Ministry to sort of implement these rules and implement a registry that is required under the rules. So this regulation only applies to businesses operating in Spain, i.e. where they are selling to Spanish residents. So essentially, that means where activities are addressed to Spanish citizens. So for example, you operate a platform or a website which is intended for Spanish consumers. So the scope of this regulation is limited to, where your sales are to Spanish consumers. The regulation applies to businesses that provide overnight accommodation, and that includes hotels and similar accommodation providers. But it also includes online booking platforms that act as intermediaries between accommodation providers and consumers. And it also applies to rental car companies as well. So the regulation requires these businesses to provide a broad range of personal and transactional data to Spanish enforcement authorities. So that data includes customer data, so traveller data, and that includes name, nationality, address of the traveller's usual residence, their contact details, and it also includes the transaction data, so the dates of the customer's stay, how they've paid, so their payment method. And this data has to be provided to the Spanish authorities for each and every booking. So a huge amount of data that has to be collected and that has to be shared. So in order to comply with this regulation, businesses will need to, firstly, they will need to register both the business and the accommodations that they're providing with the Spanish Interior Ministry. They then have to require all their customers to complete an entry form, and that entry form has to collect all the information which is required under the regulation. The businesses then have to keep a digital record of all the data that's been collected, and they have to keep that record for at least 3 years. And then lastly, and this is the key point under the regulation, is that data then has to be shared with the Spanish authorities. So they've got to report all of that data to the Spanish authorities through digital means. And actually, as I mentioned at the beginning, the Spanish Interior Ministry has set up an electronic registry where businesses can register the business, register the accommodations, and share the data that they need to with the Spanish authorities. So why, I hear you ask, why has the Spanish authority decided to go down this route? And if you read the actual regulation, the preamble to the regulation, it's very much focused on sort of national security, on terrorism threats. And that seems to be the main reason why the Spanish authorities have decided they want to collect all of this data. Because I think the first thing I thought when I saw this regulation was how is it consistent with sort of GDPR, with sort of data protection rules? But if the Spanish authorities are going down this sort of national security avenue, then they can find sort of reasons to be able to show that this data sharing is necessary for those means. But as I said at the beginning, this primarily impacts companies that are selling to Spanish consumers. But I do know that we have quite a lot of our client base that do sell internationally, do sell into the EU, and do sell to Spanish consumers, so they would be affected by this rule. So that brings me to the end of my session. I'll hand over to Reese now, who I think is going to ask some questions.
Bruna, thanks everybody. So we do have some questions in the chat, so I will pick out some of these. So the first one is, the first one's about the secret commission issue, does the commission have to be disclosed pre-sale, or is it okay if it's disclosed post-sale? So I'm assuming here this is a situation where you're seeking to get kind of the informed consent of the customer to the commission. And I would have thought it's probably consent which has to be obtained kind of pre-contract. So I'm not sure whether post contract would be sufficient. Is secret commission prohibited in other jurisdictions, or is it just limited to English law? I think it does vary by country. I believe there is an issue in Germany about this, having spoken to one of our German partner firms there about this issue. There was a particular case involving a German travel company where some sort of secret commissions were being taken, and that led to legal proceedings over there. So I think it does vary by country. I suspect that somebody like the US, with a similar common law system to the UK, will have laws around secret commission as well. But I mean, we have done a bit of work in other countries on this, and I do think it does vary by jurisdiction. Question before I ask one of the other panelists. There is an interesting question here about, I hadn't really considered, about the position of Meta Travel, so kind of price comparison websites, who may receive a commission or a payment from an OTA or an airline. Does that cause an issue? Well, I suspect it depends on, firstly, what obligations have you undertaken to the customer or to the user of the website? Possibly difficult to see fiduciary duties, but perhaps you do promise to provide impartial information and recommendations. So that category of, the disinterested advice category may bring in the prohibition against secret commission. So, in that case, the fallback position then would be to consider what kind of disclosures you could make, which are tolerable from a commercial perspective, to try to create a sufficient argument for there being informed consent. I suspect perhaps also there is an issue here about kind of the industry norm, and whether there'd be any argument to say, well, it's kind of it's kind of assumed, or it's kind of standard industry knowledge that the meta search site will be paid by somebody. So the assumption is that it's the OTAs or the airlines that's paying. So maybe there's an argument about that. But I mean, the reality is it's not, until there's a case in the travel sector on this, it's not clear. Question for Lucy on the commercial contract presentation. So I think the question is, are there any arguments about removing an indemnity for any breach of the agreement? So I think somebody's being asked to give an indemnity that any breach of the agreement will trigger the indemnity clause. Any thoughts on that?
Yeah, I mean, it's subject to negotiation. I think there is absolutely no requirement to give it. As with all these things, it depends on your bargaining power, to use that term. It's very much come over from the US, this sort of idea. So it depends whether you're dealing with a US partner or not. I think UK companies are more willing to let it go. But if you are dealing with a US company who's insisting on it, I think it's sort of chipping away at it as much as you can to, if you're the one being asked to give it, to just soften it and make it less wide than it otherwise could be.
Okay, thanks, Lucy. And then question for Farina and question for David. Question for Farina. What happens if a ticket agent's responsible to refund a consumer under the new US rules, but it hasn't received the refund yet from the airline? So what happens in those situations?
Yeah, so the ticketing agent is under the obligation to make the refund within the usual timescale. So 7 business days for credit card payments, 20 for other payment methods. However, there is an obligation on airlines to reimburse ticketing agents promptly. So in that situation, the ticketing agent will have to front the refund, but is then able to get that reimbursement from the airline.
And then David, last question for you, and this is really about whether the government has encountered any challenges in getting the changes it wants with this new employment bill. Have there been any kind of contentious areas or struggles?
Yeah, so certainly we're going to see what happens during the consultation process. The government was heavily criticised, and they have to produce an impact assessment on the changes, and the impact assessments were deemed to have been very poor. On the back of which the government has actually introduced another 53 pages of amendments to their proposed legislation already. I'm imagining this is going to get on a sort of head of steam as we go forward, and it's really a question of watch this space as the proposals evolve. I think they all stay broadly the same, but there will be some tweaks.
Thanks, David. So it's 10 o'clock, and we are going to guillotine it at 10 o'clock. So can I thank Farina, David, and Lucy for your presentations today, and also having asked you all to stick to 10 minutes, I overran massively. So thank you for bringing us back on track. And I'm conscious that there are some questions that we haven't answered. So I believe, provided that you've posted your details, that we will be able to respond to these kind of on email or through this application after the event. So we'll do that. So that's it. Thanks very much, everybody.